So, as we begin, if you have any technical issues, just go ahead and email staff@pmconline.org. Or if you lose connections, tonight's presentation is just a general discussion of topics with one of our amazing volunteer presenters. And just as a reminder, we are not providing any legal advice. So Pennsylvanians for Modern Courts has been around for actually 35 plus years. I got to fix this. We are a nonprofit, nonpartisan organization dedicated to ensuring that all Pennsylvanians can come to our courts with confidence and be heard by qualified, fair, and impartial judges. To resolve citizens' faith in the courts, which is actually very similar to what's happening currently. But 35 years ago, there was a series of public judicial scandals. And at the time, Superior Court Judge Phyllis Beck joined forces with other respected civil leaders to form PMC. We have functioned as Pennsylvania's only official court watch for 35 plus years. For the first 25 years, we were up in Harrisburg advocating for merit selection of judges. Currently, we elect our judges. We're one of 7 states that elect our judges. And to achieve this goal, we've created many, many educational programs in the past almost 10 years that are all focused on the courts. So from this one, which is criminal court, to a court basics, to family court, to, and especially this year, it's a judicial election year, which happens every other year. So there's a lot of information that needs to be shared and just a research that needs to be done in terms of going to the polls and making selections on judicial elections. So we have many programs that are happening in the fall. And this is just a list of some of them. And you can go to our website to register to learn more. But like I mentioned, this is a judicial election year, so we really, really encourage you to go out and to vote. Now I'd like to introduce our amazing speaker. So David Sonenshein is a professor emeritus at the Temple University James Beasley School of Law. David has taught at Boston University, DePaul University, George Washington University Law School, and is a graduate of Cornell University and the New York University Law School. David has won many awards, and he's also a member of our board. So right now I'd like to turn it over to David. Thank you, David.
Thank you, Michelle. Good evening, everybody. Nice to have you with us. Tonight's program is a sort of a basic discussion of the criminal justice system in Pennsylvania. And I will say what we say about Pennsylvania is true of most courts in the United States. And so we're really speaking pretty much about the American criminal justice system as we talk tonight. The first item on the agenda is the Pennsylvania court system, which is in fact very, very typical of court systems in the United States from state to state. I've been a member of the Massachusetts bar, the Illinois bar, and the Pennsylvania bar. So I've had experience in 3 states. And I will say the court system are pretty much the same, with one big exception, which is something Michelle just mentioned, and that is in most states, judges are appointed based on some sort of merit selection process. Pennsylvania, my view, sadly, is one of the lesser minority of states which elect judges. I've practiced in states that elect and states that don't elect, and I will describe a little bit later why that might matter. The court system, though, itself is, as you look at, I can turn for a moment to the next slide, is very, very simple. On the, I won't say the lowest in terms of prestige, but cases begin, the kinds of cases you read about in the newspaper, in the Court of Common Pleas, which is the great trial court in Pennsylvania. There's one in every county, so there's 67 of them. given the number of counties we have in Pennsylvania. And if you are being brought to trial, or you, anybody you know, or you're going to be a juror, is going to be involved in a trial for a felony, anything serious, it'll be in the Court of Common Pleas. You will not ordinarily hear about cases, the sort of more minor cases that are tried in the municipal court or out in the suburbs, what are called magisterial district judge courts. So we're going to focus on the Court of Common Pleas. And the way the case gets there is by a prosecutor deciding and charging somebody with a crime. There are not, generally speaking, grand juries in Pennsylvania. Almost every other state in the United States, in fact, 48 other states, charged by grand jury, that is 23 citizens who sit and hear a presentation by a prosecutor and decide whether this person who's the prosecutor would like to charge ought to be charged. But Pennsylvania and Connecticut are two states that operate just at the discretion, in that sense, of the prosecutor. The trial takes place in the Court of Common Pleas. Lawyers, obviously, from both sides. We'll talk about that a little bit later. And evidence is taken. And as you may know, the rules of evidence apply in our courts, which admit much evidence but exclude other kinds of evidence. And we'll talk about that a little later. If you are unhappy with the verdict that was received, more often than not, from a jury in the Court of Common Pleas, and by the way, there's a constitutional right to have a jury trial in the Court of Common Pleas or any trial court around the United States, your appeal would go to the Superior Court. And you have an automatic right to appeal to the Superior Court, which is a statewide court. Remember, you're going from a county court now to a statewide court, which hears appeals. And if you're unhappy with that decision, if you've lost again, you would have the opportunity to apply to appeal to the state Supreme Court. The state Supreme Court does not hear cases from everybody. They only hear the cases they choose to hear because they think that case is of particular importance. So what I'll suggest to you is you have an appeal as a matter of right to the Superior Court, and then only can have your case heard in the Supreme Court if it decides it wants to hear your case. That is, again, typical of courts throughout the United States, this system, including the federal courts. As you know, the US Supreme Court only hears about 80 cases a year, although tens of thousands are filed. The Supreme Court says we only want to hear these 80 cases. Same thing applies in state Supreme Courts around the country as well. Okay, we can then move on, having discussed the court system for a moment, to what the criminal process looks like. And this would be the process that takes place ordinarily in the Court of Common Pleas once a person has been charged and is now a criminal defendant. Obviously, the system originates with an arrest by the police. You may or may not be granted bail at a preliminary arraignment. There, it's not a question of the merits of the case. It's a question of, are you likely to show up in court if you receive bail, and are you a danger to the community? So therefore, it appears you won't show up in court if we grant you bail, or you will be a danger to the community, the court can not grant bail or grant bail, which is very, very high. It's an interesting situation, as you can appreciate. The people who can always make bail are professional criminals, organized criminals, major drug dealers, because they have lots of money. So even if the judge sets a high bail, $250,000, unfortunately, those people ordinarily can make the bail, while ordinary folks like you and me, many, of course, of the people who are charged are low-income people, would have no possibility ordinarily of making bail. You can get a bond put up by a bondsman But that, of course, requires money as well. The problem with the bail system is this, and that is if you cannot make bail, if the judge sends bail at $5,000 and you don't have a job, then you can't possibly make that bail and you will go into jail awaiting trial. Trials, by the way, in Pennsylvania must be held within 365 days of your being formally charged. And the problem with if you are in jail awaiting trial, which is where what we call the county jails is where those people are. Obviously, Philadelphia has a county jail, as all of the counties do. It's very hard to prepare your case. It's very hard to assist your lawyer. And so if you're unable to make bail or the judge says, I'll release you without bail, for example, those people have a much better chance of arranging their defense than folks who are unable to afford bail. When you are arrested, as I think you know, you are given Miranda warnings. We all know those from television. We've all watched Law and Order, which is accurate in many ways and inaccurate in many other ways. But I think we know what the warnings are. These are given, by the way, in most countries in the world, these types of warnings. And the warnings tell folks that they have the right to remain silent. I think you probably all could recite these. You have a right to counsel and a right to counsel, a free counsel, if you cannot afford to hire a lawyer, a private lawyer. Any things you say may and will be used against you in court if you choose to speak to the police during an interrogation. You're aware of these kinds of warnings. We've all heard these. You are entitled to them, actually, not just at the moment of arrest, but when you are going to be in custody. And now that that may or may not be the moment of arrest, but it's custody that gives you the right to counsel. The theory about the Miranda rights is very simple. Prior to Miranda, people would be interrogated by the police without a lawyer present. Most people cannot afford a lawyer. Probably 90% of people who are arrested could not on their own afford a lawyer. Prior to Miranda, those people will have no right to a lawyer, and many, in fact, went to trial without a lawyer in very, very serious cases. Happily, those days are over. And in fact, you now have the right after Miranda in 1966 to have a lawyer present during the police interrogation, which obviously would be very important to a suspect to make sure the police do not overreach, threaten, or do anything else that would force you to confess to something you haven't done. Once the arrest is over and you've been formally charged, as we said before, the judge will hold a preliminary hearing to see if, in fact, there's enough evidence to hold you. If there, in other words, is there any there, or is the charge silly? And there isn't really any significant evidence. Most of the time there is. Police usually don't arrest people just for the fun of it, and they do have some evidence. Then we talked about bail, et cetera, and the next step would be the trial, which again, we're all familiar with it from no other place watching TV. Lawyer shows are probably the most popular shows in America, but I will tell you, I've taught in foreign countries. I've taught in Italy and in a number of other countries. Everybody there watches Law and Order in Italian or in French or whatever's going on. And they know about as much as most of our Americans know about our system from television. Okay, when you get to trial, we talk about a number of things, including, of course, the right to counsel, which I mentioned a moment ago. And I guess we'll move ahead a little bit, Michelle, to get to counsel. Everybody has a right to a lawyer, whether or not you can afford a lawyer for trial.
All right, it's not allowing me to move. Hold
To
on.
move forward.
No, let's see what's happening here. Stay as co-host. Nope. Hold on. I think I'm frozen.
That's all right. I don't really need it.
I know you don't. We'll keep on going and we'll catch up. I'm going to figure it out.
Um, and obviously, the way a trial works is that the judge is sitting in the courtroom, obviously on the bench wearing a robe. The jury is seated to the side. Many of you might have seen this, certainly on television. The prosecutor is on one side of the courtroom in front of the judge, the defense lawyer on the other. Um, and obviously, the prosecutor is the lawyer for the county, or essentially for the county or for the state of Pennsylvania. Um, as the trial begins, what happens is the judge makes some very preliminary instructions to the jury. And then the prosecutor makes an opening statement that says to the jury, here's a preview of what we're going to prove. And then the defense lawyer gets the chance to make an opening statement, which says, you've seen it, my cousin Vinny, what that other guy said is baloney. Okay. In other words, we don't have to show, but you're going to find in the end that this defendant is not guilty. After that, the prosecutor puts on witnesses. You all know they're sworn, put their hands on some sort of a holy book. They are sworn to tell the truth, and much of the time they do, and certainly plenty of times witnesses don't. They're human beings, as you can imagine. And the government puts its witnesses on in what's called direct examination. And the prosecutor makes his or her case by asking questions of the witnesses. After the prosecutor finishes with his or her first witness, the defense lawyer gets to perform what you all know, I think, is cross-examination, where the defense lawyer tries to minimize what the witness has said or show that the witness did not have a good opportunity to see what he or she said they saw, or is not telling the truth because of kinds of things that have happened in the witness's past. The government puts on a number of witnesses, often puts in written exhibits, documents, right? And then once the government's done with its case, it rests, is the word you've all heard. And then the defense has the opportunity to call its witnesses and put its witnesses on. When they put them on their direct examination, of course, you understand, the prosecutor then gets to cross-examine the defense witnesses. The theory of our system is very straightforward. The theory is if jurors get to see a witness face to face and hear that witness and observe that witness speak, and that witness then is cross-examined, so we see all of the problems that witness might have in terms of telling the truth, then the jurors will know whom to believe and whom not to believe. Cross-examination is not done in many countries in the rest of the world. It's not done in France. It's not done in Spain. It only recently became done in Italy. And in fact, in many of the European countries, the lawyers don't even ask the witnesses the questions, but the judge does, which for us strikes us as, wow, how can that be? The judge here has been called, those of you who know sports, basically an umpire, person who calls balls and strikes. The judge doesn't determine guilt or innocence. The judge really has only two jobs during the trial. One is to decide if evidence that's offered by one side or the other is admissible. That is, if it's the kind of evidence that Pennsylvania's courts and legislature think jurors should hear. If it's not, the judge sustains an objection and excludes it. Other than that, the judge doesn't say or do very much until the end of the trial, when the judge explains the law to the jurors. Obviously, the jurors are lay people. They're regular folks who haven't been to law school. Lawyers can serve as a juror in Pennsylvania, but they never do. Nobody wants to let a lawyer serve on the jury. The fear is if there's one person in the room who's had legal training, that person might dominate the other folks who would rely on that person only because that person's been to law school. And that really is not what we want to happen. We want to have regular folks who have regular jobs and families, et cetera, make these kinds of decisions about their fellow citizens. And that's it. Then the jury goes out into a private room and deliberates. And again, you've seen this on TV. Again, eventually, it may take days. Sometimes it's taken weeks, although that's remarkable. And the jury comes back and the judge says, have you reached a verdict? And the head juror, the person selected by the jurors for that position will say, yes, we have. Judge will say, what's your verdict? And the jury says guilty or not guilty. And at that point, the jury's job is over and they are sent home and will not be coming back. But what will happen is that there will be a sentencing of the defendant, and that sentencing is done by the judge. The jury is out of the picture at this point. The judge decides on the sentence, and that sentence is decided by statute, and there's a range of sentences. The judge can go from 3 years to 10 years in some situation, in the discretion of the judge. And what the judge looks at before doing that is, having, of course, observed the trial and seen what happened in the crime, also gets the history and background of the defendant, and will consider all of those things in determining what would be an appropriate sentence for a person who has been convicted. Now, if you are not happy, as I said earlier, with the judgment of the jury that found you guilty, the government cannot appeal. So if the defendant is found not guilty, the case is over. The government does not have the right to appeal because of double jeopardy, et cetera, et cetera. Defendant has the right to appeal. Now, before we get to it, remember, you have a right to appeal to the first level of appellate court, the Superior Court. Okay? Doesn't mean you have a right to win the appeal, but you have a right to file an appeal. And then both sides file briefs and they have an argument before the court. This may take 9 or 10 months after the conviction, and the appeals court makes its decision to either affirm the conviction or reverse it and order a new trial. One thing you must bear in mind: if you watch local TV, after every big trial, the lawyer for the defendant who has been convicted, and the vast majority of defendants you appreciate are convicted, comes out and says in the loudest voice he or she can summon up, we're going to appeal. We're going to appeal this. It's ridiculous. It's outrageous. We're going to win on appeal, etc. Please understand, winning on appeal is a very rare item. Okay? I'd have to estimate that 1 out of 20 criminal convictions are reversed on appeal. Their appellate courts have great confidence in the jury system. And if they believe, by and large, unless there's been some terrible error by the judge in admitting evidence that should never have been admitted and prejudiced the jury, or told the jury the wrong law, which of course not likely to happen, right? Or misstates the law, the conviction will be affirmed and that will be it. Although you do have a right, as we said, to have the rare case where the state Supreme Court will take the further appeal and make a final decision, and may or may not agree with the decision of the appellate court. But don't be taken in this notion that appeals are easily done. A lot of people win appeals. That is not true. In fact, think about it. The only thing you can appeal, frankly, in any real sense, if you've been convicted, are really one of two things. The judge admitted evidence that was improperly admitted, evidence no jury should ever hear, one, and that evidence was so prejudicial that it likely deprived the defendant of a fair trial. The second thing is, as I said before, the judge misinstructed the jury on the law. That is very rare because in most courts now, the appellate courts have created form instructions for all sorts of crimes and everything else, for the trial judge to give. And, it's pretty hard if you're a trial judge to mess that up. So the big issue is ordinarily going to be an evidentiary question. And again, it has to be a serious error the trial judge committed by admitting a very, very prejudicial error. Okay? The appeal takes place before 3 judges, not one, and that's in the Superior Court. And if Superior Court, if the case is appealed from the Superior Court, the Supreme Court has 7 justices who will decide the case based on a majority vote. Now, one thing I mentioned before is about our judges. I practiced in Massachusetts, Boston particularly. I practiced in Illinois, or I was a member of the Illinois Bar and the Pennsylvania Bar. Illinois and Pennsylvania elect judges, and most states no longer do that. Massachusetts, for example, has a blue ribbon commission of law school deans, people like that, and they give 3 names to the governor. And the governor can only choose a judge from among those 3 names. Can't pick his or her friends, cannot pick his or her political donors. That can't be done. Those people would never make it through the merit selection. Okay? I will tell you that since merit selection was in fact adopted in Massachusetts, which happened around the time I was there, they have no judicial scandals. Illinois has had enormous judicial scandals, elected judges. Pennsylvania has had enormous judicial scandals. And the main problem, a big problem is, think about it, with elected judges, they run as Democrats or Republicans. And they're allowed to get campaign contributions. I see Michelle shaking her head. No sensible person would think this is a good idea, okay? And in fact, where do you think the campaign contributions come from in judicial elections in Pennsylvania? They come from lawyers and law firms who expect to have cases before these judges. And I don't care how much integrity a person might think he or she has. If you've got people involved in a case in front of you who've given you $500,000 for your campaign, I just think it's pretty tough to be right down the middle. Can it be done? Yeah, of course it can be done. But of course, it leads to certainly an appearance of a real problem. They had judicial scandals in Massachusetts earlier, not anymore, not for the last 40 or 50 years. And there's a reason. There are no campaign contributions. It doesn't work that way. And so that really is really going to be a problem. We have it. We're going to have it. Hate to say this. I don't think it's going away soon, although Pennsylvanians for Modern Courts was created to do something about that, among other things. But unfortunately, the politicians who have the ability to make that change, most of them love elected judges. Some of them want to become elected judges. And it's just something that both sides have not been really good about in the Pennsylvania legislature. It would probably have to be, well, I guess by statute. There won't ever be any constitutional amendment that will ever pass in Pennsylvania on that, I wouldn't think. So it's going to be with us for a while. We hope this will change, and we'll have appointed judges on merit. But that's not the situation we have at the moment. Okay, let me talk to you about a couple of things, and I really won't. Well, we can leave
I'm frozen again.
I don't need it from now on anyway.
Oh, there we go. There we go. Okay.
Okay. There's one other thing you can do if you've been found guilty and your lawyer or you discover newly discovered evidence. Even after all your appeals are done, you can bring a petition for post-conviction relief. And if a judge thinks that's enough new evidence that would change the outcome, you can get a new trial that way. 2 other points before we leave the trial and appeals for the moment. You know, when you watch TV, you think that when a person wins an appeal, that person walks out of prison and goes home. That's not true. When you win the appeal, what you win most of the time is simply a new trial. And the government has to decide, will we take the time and expense to retry this person without using the tainted evidence we used the last time? Sometimes the prosecutor says, no, I don't think we'll waste time and money on that. Person might have already served 10 or 15 or even 20 years. And often they will say, no, we will retry this person. And so it's not as if you necessarily, as you see on TV, sort of the doors of the prison open and you walk out. Ordinarily, the Supreme Court, in reversing an appeal, gives the government 90 days to decide to retry you or not. If they decide not to retry you, then you go home. Now, this obscures a very important point. 90 to 95% of people convicted of crimes in Pennsylvania, New York, California, all over the United States don't have trials. I mean, it may be surprising because every case on Law and Order goes to trial, doesn't it? Because that's what you want to watch, okay? The vast majority of people either have their cases dismissed because the case doesn't have a lot of merit, or the vast majority plead guilty by making a plea agreement, a plea bargain with the government, okay? In other words, you're facing life in prison. We will offer you something less than that if you will plead guilty and save us the trouble of a trial, okay? In some states that have capital punishment, the government will say, well, we will not seek the death penalty if you agreed to, in our bargain, to serve life in prison without parole, okay? Obviously, there's very difficult choices for a person to make. Not that every case is a capital case, obviously. But don't be, most of us from television movies think they're trials all day long. There are some federal courts where there hasn't been, they have 1% of cases go to trial. In Florida, the number of going to trial is, it's a 0.00 before you get to a number. So the vast majority of people plead guilty because it's frankly, most of the time in the interests of both sides, that there be a plea agreement and the case is resolved that way. Couple of things that I just want to make mention as well. And that is the question of, are there false convictions in criminal cases? And the answer is yes, there are. The system isn't perfect. Think about it. You know, you're not being tried by a computer. You're being tried by people who come from all walks of life. And, you know, they may be wrong. Most judges will tell you, though, that most jurors get it right. Most jurors decide a case the way the judge would if he or she were on the jury. But there are, at the moment, more than 3,000 people who have been freed who are innocent in the United States. And this has been done by, as you know, innocence projects around the country. There are also district attorneys' offices, a number of them in Pennsylvania, a large number in Texas, and all over the country that will review convictions where they think, you know what, this person was really innocent. And the most remarkable thing that people find hard to believe is that people will confess to crimes they have not committed. This is, I think most of us would say, who would ever do that? And for a variety of reasons, sometimes police misbehavior, sometimes the fact that the people who are confessing are 14 or 15 years old, do not have a lot of schooling, are sitting by themselves. They've chosen not to have a lawyer in an interrogation room, and feel a lot of pressure, et cetera, will confess to crimes they haven't committed. The most famous one you would have heard about was called the Central Park Five in New York, where 5 young men, they were teenagers, were convicted. All were innocent. They actually caught the real guy who eventually confessed, whose DNA matched the victim in that case and the victim in 10 other cases. But this is not as unusual as you might think. It's not usual. I don't want to mislead you. They interviewed police in New York, NYPD, and New York prosecutors, and they believe themselves, this is prosecutors and police now, 5 to 15% of the confessions they get in New York are false, are made by innocent people. Now, remember who we're interviewing here. We're surveying police and prosecutors, and they know that some fairly significant percentage, remember, New York has 8 million people. 15% of the number of people arrested and confessing in New York is a lot of people, okay? And they will tell you, yes, we understand there are false confessions. It's a problem when you're dealing with a human-run system. It is a problem, and we can do things about making interrogation more scientific, which they've done in Europe and is starting to happen here, including in Pennsylvania, I'm happy to say.
And what does that mean, David? Scientific, more scientific.
Yeah, what it means is instead of like on Law and Order, where you put a guy in a room, trick him into waiving his counsel. Okay, this is the Law and Order routine.
By pressure.
And,
So
and
just
start
by pressure.
and start screaming at him.
Yeah.
Sometimes physical, not so much anymore, but screaming at him, scaring him, telling people, if you don't confess, we'll take your children away. I mean, there are all kinds of things that have been done. Not in every case, please don't misunderstand. In Europe, and the biggest problem is police in America are allowed to lie to the suspect about the evidence. For example, we have your DNA on the victim when they don't. We have 30 eyewitnesses who saw it when they have none. We have fingerprints when they have none. And you appreciate, I've talked to British police who do it the scientific way, which I'll describe in a moment. And they said to me at the police academy in London, if they did that to me, these are career police, I'd confess. I'd make a deal. I figure if they got my DNA, I have no chance. So if they offer me 5 years instead of 10, I'll take the 5. These are career police in England saying if they were in the position of an American suspect, that's what they would do because that pressure is so enormous. In England, if you lie to a suspect in that way, you are no longer a policeman in England. Your job is taken away. You're now going to have to find a new job. Okay? We don't want people like that as police officers in England. Okay? All of interrogations in England are videotaped from start to finish. That is not done in many places in the United States. And so you don't ever know what really happened. And when the suspect says they did this to me or that to me, the police officer said, no, we didn't. The judge is in a very, very difficult position. The question Michelle asked, what is scientific? It's based on the way psychologists talk to people to get information, which is we want to hear you tell us first what happened, your point of view. Then we'll confront you with some evidence. It has to be real evidence, not made up evidence, okay? And see if you can explain that. Here, the police decide you're guilty and then tell you the evidence and try to make you agree with what they've told you with a variety of kinds of pressure, some of which is just inherent in the fact that you're by yourself in a room with 2 or 3 grown-up detectives and you're a 15-year-old kid. Or I will just add one other point because we're about out of time. Bear in mind that a fair number of people who are convicted of crimes in America are either significantly mentally ill or have intelligence issues in terms of IQ, et cetera, which makes it very difficult for them to handle the kind of pressure they get from police. I'll just say I remember the Cook County Jail superintendent in Chicago said the Cook County Jail in Chicago is actually the largest mental illness asylum in Illinois. Said 90% of the people sitting in the Cook County Jail today are either mentally ill or have mental deficiencies that would make it essentially impossible to freely make a confession. In England, you're not allowed to interrogate those people. You're forbidden. Doctor comes in and says, no, can't do it. Can't do it. Here, that's perfectly okay. And it's a real problem because, and then you go to prison and have lots of mentally ill people in prison, and you can imagine how that goes. How that goes. Okay. So we have a system. I think our system is basically good in terms of it relies on people. And a jury, remember, all 12 have to agree, which is important to get a verdict. But are there problems? Of course there are. The problems are because human beings are engaged in running the system. And those problems, some may be soluble, some just may be, the kind of thing where that's the way it's going to happen sometimes. Okay. Happily, I will tell you, most people convicted of crimes are guilty. Most people who plead guilty are guilty. But there are too many people, too many, to me, one is too many, but too many people who may not be or are not, we know are not, who are in jail for some of them for life, for many years. Some have been executed, particularly in Texas, in Florida, where a number of innocent people, and the governor knew they were innocent, still had those people executed. That would not happen in Pennsylvania. The last 6 governors we've had, both parties, have not been signing death warrants. Certainly wouldn't do it, I wouldn't think, if they knew the person was innocent. That's not a problem we have, I'm happy to say. Okay, I think we're out of time, Michelle, am I right?
Yeah, we are. Does anybody have any questions? There's none in the chat. But please, this is the time to do that if you do have any questions. Um, I don't see any, David.
Well, right.
And just to let everybody know, like I said before, this recording will be on PMC's website. I'm going to stop recording right now. Where's my stop record? Pause. Okay. Um, Thank you so much, David. This has been so informative, and we really appreciate your time, your knowledge, your expertise. And if you do have questions afterwards and you've looked at the recording and the video, just send staff@pmconline.org the question, and we'll be more than happy to see if we can answer it or provide you with some resources to reach out for it. Thank
Okay.
you so much, everyone. And please go on our website and definitely register for some of our judicial election programming. Take care.